Anything else?
Well, if you are, if say you run a red light and it gets caught on camera and you never have to delete it, then this could greatly, and then at that time you never get prosecuted, but years later, for example, it gets brought up in a different lawsuit against you, then you're getting punished for something you've done many years ago, and you can see that before technology increased like this would never have happened.
Where's the Fourth Amendment violation in that?
Well, because even though public hasn't been held to be outside your reasonable expectation of privacy, with being able to store data, it's become more invasive in these cameras, and so therefore you need to protect a person's privacy in the future so that you can't continue using this information against them.
However, this isn't saying that all data that's collected for long periods of time is invasive. It's depending on the case. For example, these specific cases with the airports and the red lights, where the information gathered can be used against you again, but with the NSA call database, the only information being gathered is information about when you called and who you called and other information that's not really as meaningful because you can't be harassed about due to this information.
The Fourth Amendment protects persons, places, and their papers should things like iPhones, and also the Constitution is a living document. I mean, it's open to interpretation, and certainly the framers could not have foreseen an iPhone. I couldn't. But anyway, so should that be interpreted as papers in the modern world?
I would say that it should. We see in the oral arguments of Ontario v. Kwan, Chief Justice Roberts actually had an issue with figuring out where this reasonable expectation should now stand given all the new technology. And he found that it should really be based about the person's age and also how they feel about this technology, how well they can use it. So in the case of the iPhone, I would say that it should be included. We are now used to this new technology.
Ontario v. Kwan is a case concerning a pager. A policeman exceeded his text limits, and as a result, his boss came and read all this text. So this is in front. The question at stake is whether cell phones and pagers are also protected.
Can you imagine any form of data mining that does not implicate the Fourth Amendment at all?
Well, I can imagine when it happens with third parties, it has not been protected by the Fourth Amendment. An example of this is Communications for Law Enforcement Act of 1994, CALEA. It allows government to go backdoor into all these telecommunication companies and get information from them that they did data mined, and this does not violate the Fourth Amendment and doesn't have Fourth Amendment implications in that way.
Well, what about, for example, mining a database generated by a municipality's division of motor vehicles in the context of motor vehicle registration, driver's license issuance, and that sort of thing? Any Fourth Amendment implications in mining that kind of database?
Well, I feel like this specific type of data mining is, although it might be, the intrusiveness of it is not really extreme, and also it might be important to have this slight intrusion into your life in order to say you have a person's car and you need their license and registration, and you have that information in the database. And this is similar to, say, the case of Smith v. Maryland, where the Supreme Court ruled that any information sent to a third party is not an intrusion into the Fourth Amendment. And in this specific case, pen registers were ruled to be constitutional because they simply, the phone company already registered the number that was called. So I'd say this is such a slight intrusion, but it helps when tracking down people who have committed crimes, then this is fine and not violating your Fourth Amendment.
Well, with respect to information voluntarily given in the context of driver's license applications and motor vehicle registration, is there any intrusion at all Is there any search in the constitutional sense at all if the database is mined later?
Well, in the sense of a search that occurs, actually people are voluntarily giving up this information, and that's one of the reasons that these third-party, like such as the call database or the pen registers, is constitutional, because these people are calling the person, so therefore they're willingly submitting their number as well as calling the person. So this is constitutional.
But on the other hand, when a person, in Stanley's example, is giving out their number or calling someone, they would never expect the government to be listening in. So even though you're voluntarily giving out to a third party, you also have to think about if in that decision they're actually voluntarily giving up to the government, which they're not. So that's a little bit of a different issue.
Okay, let me ask this question. Let me put two pieces together from your opening. There was a discussion or a suggestion that if you purchase something at a store, you have no reasonable expectation of privacy. But then there was a concern about data mining with respect to information from hotel rooms in Las Vegas. How do those two things fit together?
Well, in Katz v. US, it was decided that your expectation of privacy can travel around with you. And for example, in a hotel, you do have a reasonable expectation of privacy. And in this case, it was in a phone booth. You can wiretap outside. You couldn't wiretap outside. So this has to do with the store because technically it would be able to travel around with you. There is no expectation of privacy. However, in a store, it's a public setting, and you really, if you think about it, you really don't have expectation of privacy.
Because consent is one of the warrant exceptions.